Hey everybody, welcome, welcome, welcome. I'm Leonard French, your favorite copyright attorney, and we're getting started here in just a second as soon as I fix all of my OBS things, because I wanted to hit the streaming button before anything else on this one. This is absolutely nuts. I don't even have a hat. Where is a hat? Let's wear this. Let's wear this hat. What do we think of this hat for the stream? So, everyone who's joining, guess who won their case? H3h3 wins again. We all expected this. Come on, how many of you are actually surprised that H3h3 won the case? I mean, come on. We went over this about 100 times. It looked like Judge Forrest had given us an indication that she was going to rule in the H3h3 case. So, see ya. Have a nice day. That was the end of the stream. No, we're going to go read this 22-page opinion from Judge Forrest and go over what she... I haven't even read it. I have no idea what she has to say, whether it's nice, whether it's mean, whether it drives the point home, or whether she... I don't know. What does she go on about for 22 pages? So what do you think? We go over all of this together. All right, so please bear with me. I just stopped everything I was doing today, which was not an H3h3 review. And okay, is the audio good? Do I look okay? Is the lighting okay? Okay. Are there dogs? Hey, anybody want to say hi on stream? Are we all lazy dogs? We're all lazy dogs. So maybe I'll carry a dog in here by force later, but we'll save that for later. So hello everyone, 250 of you here right now. It's amazing. Thank you so much for joining me. Let me quick send a link wherever I can find one. I guess it's, where the heck is the link to the, there it is. Let's tweet this out. H3h3 wins. Let's go over Judge Forrest's opinion. Live now. All right, little overkill, but you know, it works. So, all right, I know you're all eager to get to this. Holy crap, there's 611 of you here. I don't want to wait that much longer, but while it's growing, we might as well just talk for a moment. So what happened in the H3h3 case before this? Thank you very much for the donation, whoever that was. It's scrolling by so fast. Oh, Zub Ruber, thank you very much. Papa bless. So what happened in the H3h3 case was that Ethan and Hila had made a video. It had critiqued or criticized, like really pretty heavily criticized, what Matt Hoss was doing in his videos, and Matt Hoss issued DMCA claims, I think, against them, or sued them. I don't know if he went straight to suing them or if he did a DMCA claim. Somebody remind me. But he did sue them, first for copyright infringement, and then for defamation, and then for something else. I forget what the third count was. We had speculated that H3h3 would win basically throughout the whole thing, but then we kind of confirmed that when Judge Forrest said that one of the parties had made a good case on summary judgment, and only one of the parties had made a complete case on summary judgment, so that seemed to favor H3h3. I think we have confirmation of this now. Okay, I'm going to begin with the opinion, and we'll just do some catch-up stuff if more people come and want to hear more about it. So let me change my scene here and get my Adobe Acrobat up, and let's begin. This is in the United States District Court for the Southern District of New York. This is the Matt Hoschenzade plaintiff versus Ethan Klein and Hila Klein defendants. So remember, plaintiff is Matt Hoss, defendants are H3h3. This is Judge Forrest's opinion and order, and it was released today, just maybe within an hour of now, I think is how long ago it was released. Let me just one more time check these chat. Thank you all for your donations. Michael, Is there an update to the h3h3 case? Jonathan, thank you very much. This had better not be clickbait. And Super Dur, $5. Thank you. h3h3 wins. All right, so let's begin. This action principally concerns whether critical commentary on a creative video posted on YouTube constitutes copyright infringement. Matt Haas, plaintiff, filed this action in response to a video, the Klein video, created by the defendants in which they comment on and criticize plaintiff's copyrighted video, the Haas video. The Klein's criticism and commentary is interwoven with clips from the Haas video. The operative complaint alleges that defendants infringed plaintiff's copyrights, made misrepresentations in a counter-takedown notice in violation of the Digital Millennium Copyright Act, and defamed plaintiff. Before the court are dueling motions for summary judgment. Just root beer, just non-alcoholic root beer. I do not drink on stream. Before the court are dueling motions for summary judgment. The key evidence in the record consists of the Klein and Haas videos themselves. Any review of the Klein video leaves no doubt that it constitutes criminal commentary of the Haas video. There is no doubt that the Klein video is decidedly not a market substitute for the Haas video. Note that this is the major factor she's going straight to. The market substitute, the usurpation of the market. The Klein video was not a substitute in the sales market, the advertising market, the video market for the Haas video. The Haas video was still marketable. That's not the standard that it remains marketable, but rather the Klein's video wasn't even a substitute for it. For these and other reasons set forth below, defendants' use of clips from the Haas video constitutes fair use as a matter of law. Furthermore, it is clear that defendants' comments regarding the lawsuit are either non-actionable opinions or substantially true as a matter of law. For these and other reasons set forth below, plaintiff's defamation claim fails. Defendant's motion for summary judgment is therefore granted, and plaintiff's motion is denied. Wow. That is quite an introduction. She just went straight for it, shut everybody down. This is not a misuse of Matt Haas's material. This is exactly a fair use. It is exactly what we've been saying. It is critical commentary, and what h3h3 has been doing, you can do that too. You could probably use this case as a model for what constitutes critical commentary and critique and fair use, at least in the Southern District of New York. But I'm guessing she's going to be citing some laws and rules and things that will be a little bit more precedential, a little bit more authoritative than just a local court's opinion. But we'll see. Let's go back to it. Background. The following facts are taken from the party's submission under Rule 56.1 and are undisputed unless otherwise noted. Rule 56.1 is regarding the motion for summary judgment and submitting facts that are undisputed. Each side submits what they believe are undisputed facts, and then the parties get to dispute the facts, and the judge has to decide sort of ahead of trial, and the judge here decided that we have enough evidence and facts to decide things ahead of trial. Plaintiff is a filmmaker who posts original video content on YouTube. He has written and performed in a collection of short video skits portraying encounters between a fictional character known as Bold Guy, played by Plaintiff, and various women whom Bold Guy meets and pursues. The allegedly infringed work at issue here is a video skit titled Bold Guy vs. Parkour Girl, the Haas video, in which the bold guy flirts with a woman and chases her through various sequences. Defendants also disseminate their work through YouTube. On February 15, 2016, defendants posted a video titled The Big, the Bold, the Beautiful. This is the Klein video on YouTube. In this video, defendants comment on and criticize the Haas video, playing portions of it in the process. The Klein video opens with commentary and discussion between Ethan and Ela Klein, followed by segments of the Haas video, which they play, stop, and continue to comment on and criticize. The Klein video, which is almost 14 minutes long, intersperses relatively short segments of the Haas video with long segments of the Klein's commentary, ultimately using 3 minutes and 15 seconds of the 5-minute, 24-second long Haas video. The Klein video is harshly critical of the Haas video and includes mockery of plaintiff's performance and what the defendants consider unrealistic dialogue and plot lines. In addition, defendants' commentary refers to the Haas video as quasi-pornographic and reminiscent of a cringe tube genre of YouTube videos known for cringe-worthy sexual content. As critical as it is, the Klein video is roughly equivalent to the kind of commentary and criticism of a creative work that might occur in a film studies class. On April 23, 2016, plaintiffs submitted a DMCA takedown notification to YouTube regarding the Klein video. YouTube took down the Klein video the same day. Defendants submitted a DMCA counter-notification challenging the takedown on the basis that the Klein video was, inter alia, fair use and non-commercial. 3 days later, this action was filed. On May 24, 2016, defendants posted a new video on YouTube titled "We're Being Sued," the lawsuit video, which discussed this action and criticized plaintiff for filing it. In response, plaintiff amended his complaint to include a defamation claim. Following a period of discovery, both parties now move for summary judgment. With me so far? That's just our background, but I want to make sure you're still here, so give me 30 seconds. $50 donation from Morseapple. You are great. I love that you take the time to break down the legalese for us. Thank you very much, Morseapple. I appreciate the $50 donation. Wow, there's 1,773 of you watching according to my analytics here. That's really amazing. Let's not leave you waiting. I have several windows open, though. Legal principles. Summary judgment may be granted when a movement shows, based on admissible evidence in the record, that there is no genuine dispute as to any material fact and that movement is entitled to judgment as a matter of law. Let me take a second and break that down. So summary judgment is a procedure. Those are special words, term of art, summary judgment. May be granted when a movement shows. Movement is the person asking for summary judgment. Based on admissible evidence. Admissible evidence would be evidence that is admissible in court under the rules of evidence, the federal rules of evidence, which you can read. They're public. They're very complicated, but they sort of make sense when you figure it out. In the record, which means evidence that's admissible that was filed in the record, filed in court, filed on the docket. That evidence has to show that there is no genuine dispute between the parties. They don't have a dispute, a genuine, real dispute. You can say it all day long, but it has to be an actual, real dispute as to any material fact, as to any fact that is genuinely, sincerely at heart of the issue. Material, germane, salient fact. No genuine dispute of material fact, and that movement is entitled to judgment as a matter of law. That not just that there is no dispute, but that the law also lines up with movement's request for judgment. So if all that lines up, you get summary judgment. It's a very high, difficult standard to meet, but when appropriate, it's a very good tool for getting rid of a case before it goes to trial. Hey, guess what? Guess who doesn't have to pay any more money to go to trial, etc., 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 assuming Matt Haas isn't going to appeal this and somehow get something like that. The chances of that are extraordinarily slim. The moving party bears the burden of demonstrating the absence of a genuine issue of material fact, meaning h3h3 in their summary judgment motion had to make their complete case. They can't leave anything out. They have to demonstrate that there is no issue of material fact. In reviewing a motion for summary judgment, the court construes all evidence in the light most favorable to the non-moving party, and draws all inferences and resolves all ambiguities in the non-moving party's favor. That means the opponent to the summary judgment motion gets the benefit of all doubts. If there is any ambiguity or equivocation, the court will assume that that fact falls in the non-moving party's favor when making a determination of summary judgment. So you can see how amazingly high this standard is. The judge is even going to be favorable to Matt Haas on all things that are not like proven by the evidence, and so Matt gets the benefit of the doubt on all those things. And this worked in reverse when we're considering the other summary judgment motion, but I'm going to be referring to the one that won. So disregard any thought of Matt Haas's summary judgment motion. I'm talking about h3h3's. The court's role is to determine whether there are any triable issues of material fact, not to weigh the evidence or resolve factual disputes. So if there are factual disputes, or if there would be something that has to be tried, then you just deny the summary judgment motion and go to trial on those issues. Fair use. Fair use is an affirmative defense to copyright infringement. An affirmative defense means that you did the thing, you committed the act that constitutes copyright infringement, but you have a defense to a claim or liability for copyright infringement. So they copied, h3h3 definitely copied, but they have a defense to the copying. So they're not, that's what's called an affirmative defense. You're affirming the act was done, committed, but you're saying you had a reason why it's legal. It is a judicially created doctrine, first explicitly recognized in the Statute of the Copyright Act of 1976. That's fair use. Fair use is a judicially created doctrine, first explicitly recognized in statute. So fair use was recognized in the courts before it was recognized in the law, is what that's saying. In determining whether the use of any work in any particular case is fair use, the courts consider these non-exhaustive factors: the purpose and character of the use, including whether such use is of a commercial nature or is for non-profit educational purposes, the nature of the copyrighted work, the amount and substantiality of the portion used in relation to the copyrighted work as a whole, the effect of the use upon the potential market for or value of the copyrighted work. That fourth factor is a very important one. No one single factor is categorically determinative. In other words, you don't win on one factor in this open-ended and context-sensitive inquiry. This is a great, I'm going to use this line, open-ended and context-sensitive inquiry. I get a lot of fair use questions, and people say, if I use a magazine article in my article, will I get in trouble? I don't know. I need to see specifically. I need to see the context. It is a context-sensitive inquiry. It is open-ended. You continue to look till you find all the things. So every fair use analysis is an analysis, and any attorney, any person is going to have to spend time on that analysis, is going to want to get paid, basically. So that's why we can't just have like a form on a website where you type in what you're doing and you get a fair use yes or no. It doesn't work that way. The Second Circuit, which is where the Southern District of New York is, has held that when the material facts in the record are undisputed, the fair use factors are properly considered as a matter of law and therefore may be decided on motion for summary judgment. So the judge is citing a case that allows this ruling to be made on summary judgment. You can determine fair use on summary judgment. Citing a case, Blanche, although fair use is a mixed question of law, in fact, this court has on a number of occasions resolved fair use determinations at the summary judgment stage where there are no genuine issues of material fact. Although no factor is independently determinative, the heart of the fair use inquiry is the first factor, whether the use is transformative by adding something new and with further purpose or different character. The central purpose of this investigation is to see whether the new work merely supersedes the objects of the original creation, or instead adds something new with a further purpose or different character, altering the first with new expression, meaning, or message. A use is transformative if it does something more than repackage or republish the original copyrighted work. In other words, the would-be fair user of another's work must have justification for the taking. It is well established that among the best recognized justifications for copying from another's work is to provide comment on it or criticism of it. Indeed, the Second Circuit has held that there is a strong presumption that Factor 1 favors the defendant if the allegedly infringing work fits the description of uses described in Section 107, including criticism and comment. The uses identified by Congress in the preamble to 107, criticism, comment, news reporting, teaching, scholarship, and research might be deemed the most appropriate for a purpose or character finding indicative of fair use. Where the defendant's use is for the purpose of criticism or comment, Factor 1 will normally tilt in the defendant's favor. Accordingly, courts have regularly found fair use after holding that the purpose or character of an allegedly infringing work was criticism and or comment. See NXIVM Corp. That's probably a number, I don't know. Affirming district court denial of preliminary injunction after finding that defendants' allegedly infringing writings were undoubtedly transformative secondary uses intended as a form of criticism. A Louis Vuitton case holding defendants' line of tote bags made fair use of plaintiff's copyrights in part because parody, like other forms of comment or criticism, has an obvious claim to transformative value. Another case holding the play 3C makes fair use of the television series Three's Company, in part because the play criticizes and comments on Three's Company by reimagining a familiar setting in a darker, exceedingly vulgar manner. The second factor, which is rarely found to be determinative, calls for recognition that some works are closer to the core. Hey, you ever wonder if you find a typo in a judge's opinion that's 5 months old? Everybody does it. I believe in my TRO request, there were some places where my dictation had been translated wrong and I didn't notice it because it wasn't a spelling error. The second factor, which is rarely found to be determinative, calls for recognition that some works are closer to the core of intended copyright protection than others. A work that is in the nature of an artistic creation falls close to that core. Thus, a determination that an allegedly infringed work is fictional or creative weighs against a finding of fair use. The third factor is a consideration of the amount and substantiality of the portion of the copyrighted work used in relation to the copyrighted work as a whole. This requires courts to consider not only the quantity of the materials used, but also their quality and importance. The extent of permissible copying varies with the purpose and character of the use. Finally, the fourth factor focuses on whether the secondary use usurps demand for the protected work by serving as a market substitute. This factor is concerned with a secondary use that, by offering a substitute for the original, usurps a market that properly belongs to the copyright holder. In weighing this factor, a court properly looks not only to the extent of market harm caused by the particular actions of an alleged infringer, but also whether unrestricted and widespread conduct of the sort engaged in by defendant would result in a substantially adverse impact on the potential market for the original. The question is whether the allegedly infringed work serves as a market substitute for the allegedly infringed work, not merely whether the market for the allegedly infringed work was harmed. Campbell noted that critical parodies may legitimately aim at harming the market for a copyrighted work, and that a lethal parody, like a scathing theater review, kills demand for the original work, but does not produce a harm recognizable under the Copyright Act. If the secondary work harms the market for an original through criticism or parody rather than by offering a market substitute, it does not produce a harm cognizable under the Copyright Act. To the extent that the copying damages a work's marketability by parodying it or criticizing it, the fair use finding is unaffected. Accordingly, the role of the courts is to distinguish between biting criticism that merely suppresses demand and copyright infringement that usurps it. Excuse me. If the allegedly infringing work is not properly considered a market substitute for the infringing work, the fourth factor weighs in favor of the defendant. Cites a Google case holding that the snippet view of books digitized as part of the Google Books project did not constitute an effectively competing substitute to the original. As a general matter, criticisms of a seminar or organization cannot substitute for the seminar or organization itself or hijack its market. On the Dmca misrepresentation claim, the Dmca governs the means by which copyright holders can notify online service providers that their sites host or provide access to allegedly infringing material. The Dmca provides that such notices, commonly referred to as takedown notices, must include a statement that the complaining party has a good faith belief that the use of the material in the manner complained of is not authorized by the copyright owner. The Dmca further provides a mechanism, commonly referred to as a counter-notification, through which creators of allegedly infringing works can effectively appeal a service provider's decision to remove or otherwise disable access to their work. Similar to a takedown notice, a counter-notification must include a statement under penalty or perjury that the subscriber has a good faith belief that the material was removed or disabled as a result or mistake or misidentification of the material to be removed or disabled. Relevant to the current action, the Dmca prohibits knowingly materially misrepresenting that material activity is infringing or that material or activity was removed by mistake or misidentification. The Ninth Circuit has held that, in submitting a takedown notification, a copyright holder need only form a subjective good faith belief that the use is not authorized. In other words, a copyright holder is not liable for misrepresentation under the Dmca if they subjectively believe the identified material infringes their copyright, even if that belief is ultimately mistaken. It is clear to this court that the same subjective standard should apply to the good faith belief requirement for counter-notifications. If the same standard did not apply, the creators of allegedly infringing work would face a disparate and inequitable burden in appealing an online service provider's decision to remove or disable access to their work. Given the fact that the statutory requirements for takedown notices and counter-notifications are substantially the same, the Dmca plainly does not envision such a scheme. Citing Rossi, juxtaposing the good faith proviso of the Dmca with the knowing misrepresentation provision of the same statute, reveals an apparent statutory structure that predicated the imposition of liability upon copyright owners for only knowing misrepresentations regarding allegedly infringing websites. Defamation. Because falsity is an element of defamation under New York law, truth is an absolute defense to a defamation claim. Oh, citing the Tannerite sports case. A slanderous statement, by definition, must be false. Under New York law, truth is an absolute unqualified defense to civil defamation. It is well established that a statement not need be completely true, but it can be substantially true, as when the overall gist or substance of the challenged statement is true. The common law of defamation overlooks minor inaccuracies and concentrates upon substantial truths. A statement is substantially true if the statement would not have a different effect on the mind of the reader from that which the pleaded truth would have produced. Again, citing the Tannerite sports case. Let's try that one again. A statement is substantially true if the statement would not have had a different effect on the mind of a reader. That's basically what we're talking about with substantial truth. When the truth is so near to the facts as published that fine and shaded distinctions must be drawn and words pressed out of their ordinary usage to sustain a charge of libel, no legal harm has been done. When a court interprets a publication in an action for defamation, the entire publication, as well as the circumstances of its issuance, must be considered. Again, citing Tannerite Sports. Along similar lines, statements of pure opinion, as opposed to statements of fact, are not actionable as defamation under New York state law. New York law absolutely protects statements of pure opinion such that they can never be defamatory. That said, when an opinion implies a basis in undisclosed facts or facts known only to the author, it may be actionable as a mixed opinion. What differentiates an actionable mixed opinion from a privileged pure opinion is the implication that the speaker knows certain facts unknown to the audience which support the speaker's opinion. The dispositive inquiry is whether the challenge statement can reasonably be construed to be stating or implying facts about the defamation plaintiff. Discussion. This might be what you've been waiting for. We've been going over the law, and you can see there is a lot of good law on what Judge Forrest has been citing. This here is her discussion. So pardon me for one moment. I clear my nose. Claim 1, copyright infringement. The court's review of the Klein and Haas videos makes it clear that Claim 1, in which plaintiff alleges that defendants infringed plaintiff's copyrights, must be decided in defendant's favor. The first fair use factor, and the most important, weighs heavily in defendant's favor. As discussed above, criticism and comment are classic examples of fair use. The Klein video is quintessential criticism and comment. Illustrative examples include. All right, let's just take for a moment here. The judge just said the Klein video is quintessential criticism and comment. Quintessential is like the very essence of criticism and comment is what she is saying. So she's basically saying their video is the model of criticism and comment. So let's just take that for what it is right now. That she's saying they did everything properly, basically, with that statement, as far as their use of copyrighted material. Ethan Klein remarks that Bold Guy comes from an older day of YouTube, refers to the plaintiff as the king of CringeTube. Ethan Klein mocks the video's opening title sequence, mimics the movement of the words by performing a dance in his seat. After watching what they apparently consider a lewd and unrealistic opening sequence, defendants point out that plaintiff wrote the script, and Ethan Klein remarks this is how Matt Haas sees the world, says more about him than anyone else. Defendant sarcastically compliments the sleeveless hoodie that Bold Guy wears, calling it one of the classiest pieces of clothing you can own. Defendants mock the fact that plaintiff included a line in the script complimenting his own strong shoulders. Ela Klein expresses irritation with the female character, stating that the female characters in Bold Guy videos are always so annoying and he writes them like that. Defendants engage in extended criticism and mockery of the female character's statement, "Catch me and I'll let you do whatever you want to me." Defendants mock plaintiff's parkour ability, sarcastically stating that plaintiff thinks he's a parkour expert. Ethan Klein criticizes a scene in which Bold Guy rapidly moves from one location to another, stating that this scene broke the realism of the video. Irrespective of whether one finds it necessary, accurate, or well executed, the Klein video is nonetheless criticism and commentary on the Haas video. So let's bookend what we just said. She then says that one could find their video unnecessary, inaccurate, or unwell executed. I'm not saying that she's finding it that way or that she's saying that it is found that way. She's just saying it doesn't matter whether you find it necessary, inaccurate, or well executed. It is criticism and commentary. So she's saying it doesn't have to be good. She's not saying anything about whether the Klein's video is good or not, because that's not the legal standard for fair use. It can be a terrible video that's trying and succeeding, hopefully, at making some kind of criticism or commentary. Thus, like these other three cases, this first factor weighs in defendant's favor. The second factor examines the nature of the allegedly infringed work. Defendants argue that the Haas video and plaintiff's Bold Guy video skits are factual rather than creative in nature because plaintiff has said he draws inspiration for the character from his own experiences. So there's second typo. From his own experiences and personality. The court disagrees. Plaintiff's videos, including the Haas video, are entirely scripted and fictional, regardless of whether the plaintiff draws on himself for the Bold Guy character. If creative works were deemed nonfiction, whenever an author relies on his or her own experience, the fiction genre would be defined almost entirely out of existence. Since the Haas video is a creative work, the second factor weighs against a finding of fair use. So Haas gets one. Haas won the second factor of fair use. Yay! He can go home happy, right? The third factor examines the amount and substantiality of the portion of the copyrighted work used. Defendants argue that the third factor weighs in their favor because plaintiff's video constitutes only a small portion of the content of defendants' videos. Defendant's analysis gets the math backwards. The third fair use factors consider what proportion of the copyrighted work to the allegedly infringing work uses, and then how well tailored that use was to the allegedly infringing work's purpose, no matter how long or large the allegedly infringing work is. Here, defendants use a number of short segments of plaintiff's work, interspersing their commentary and critique along the way. It is certainly true that when one adds up all of the segments used, the total amounts to 3 minutes and 15 seconds of a 5 minute and 24 second video. The law is clear, however, that the quantity alone is not determinative. It is evident that to comment and critique on a work, clips of the original work may be used. Parody must be able to conjure up at least enough of the original to make the work the object of its critical wit recognizable. Copying does not become excessive in relation to parodic purpose merely because the portion taken was the original's heart. A parody must take recognizable material from the original in order to convey its message. Without using actual clips, the commentary and critique here would lose context and utility. Here, the extent and quality of importance of the video clips used by defendants were reasonable to accomplish the transformative purpose of critical commentary. This factor is therefore neutral. A great deal of plaintiff's work was copied, but such copying was plainly necessary for the critique and commentary. The fourth factor, the commercial impact the allegedly infringing work has had on demand for the Haas video, also weighs in favor of defendants. The purpose of the fourth factor is to determine to what degree an allegedly infringing work usurps demand for the copyrighted work, thereby resulting in a loss for the infringee or unjust enrichment for the infringer. Campbell states the role of the courts is to distinguish between biting criticism that merely suppresses demand for copyright infringement, which merely suppresses demand, and copyright infringement which usurps it. In considering the fourth factor, our concern is not whether the secondary use suppresses or even destroys the market for the original work or its potential derivatives, but whether the secondary use usurps the market for the original work. Here, it is clear to the court that the Klein video does not serve as a market substitute for the Haas video. Anyone seeking to enjoy Bold Guy versus Parkour Girl on its own will have a very different experience watching the Klein video, which responds to and transforms the Haas video from a skit into fodder for caustic moment-by-moment commentary and mockery. Because the Klein video does not offer a substitute for the original, it does not indeed and cannot usurp a market that properly belongs to the copyright holder. The fourth factor weighs in a favor of determination of fair use. Count 2, Dmca Misrepresentation. The court has held that the Klein video constitutes fair use, and further that the Klein video... Yeah, hang on. Simmer down. The court has held that the Klein video constitutes fair use, and further, that the Klein video does not infringe plaintiff's copyrights. Accordingly, it is clear to the court that Claim 2, which alleges that defendants made misrepresentation in their DMCA counter-notifications, must also be dismissed. It is evident that a statement cannot be a misrepresentation if it is factually accurate. We are going to mute my phone since it keeps going off. But even if this court held that the Klein video was not fair use, the court would still dismiss Claim 2, because defendants clearly had a subjective good faith belief that their video did not infringe plaintiff's copyrights. It is undisputed that defendants understand the concept of fair use and have an established practice for ensuring their videos make fair use of copyrighted material. It is also undisputed that defendants filed a counter-notification on August 26, 2016, alleging that the Klein video constituted fair use. This undisputed evidence clearly establishes the subjective good faith belief required under 17 U.S.C. Section 512. Plaintiff has failed to proffer any evidence that suggests defendants lacked a subjective good faith belief and therefore has failed to create a triable issue. Accordingly, Claim 2 must additionally be dismissed for that reason. Claim 3, defamation. Based on this court's review of the lawsuit video, it is clear that Claim 3, in which plaintiff alleges that defendants defamed plaintiff, must be dismissed. First, as plaintiff has acknowledged, the lawsuit video is replete with non-actionable opinions. New York law absolutely protects statements of pure opinion. For example, Ethan's statement that I think the heart and soul of this is that he doesn't like that we made fun of him, and so he's suing us, is a quintessential statement of pure opinion. Nothing about Ethan Klein's statement suggests that his opinion is based on any non-public facts about plaintiff, therefore the statement is clearly not actionable as a mixed opinion. The only other allegedly defamatory statement explicitly identified by plaintiff is Ethan Klein's assertion that several months passed and nothing happened prior to the litigation. But because that statement is substantially true, it is non-actionable. As previously noted, a statement is substantially true if the statement would not have had a different effect on the mind of the reader. Here, plaintiff argues that Ethan Klein's failure to mention that plaintiff sent a warning email on August 2nd makes Ethan Klein's statement defamatory. Plaintiff further argues that Ethan Klein's omission is defamatory because it paints plaintiff as a trigger-happy litigant who immediately activates his lawyers when criticized. Plaintiff is mistaken for at least two reasons. First, viewing the lawsuit as a whole, the clear import of Ethan Klein's statement that nothing happened is that defendants were surprised and disappointed by plaintiff's decision to file a lawsuit months after the Klein video was first posted. In Tannerite Sports, when a court interprets a publication in an action for defamation, the entire publication, as well as the circumstances of its issuance, must be considered. Plaintiff's objection to the word nothing is hyper-literal and based on a strained and unsupported interpretation of the lawsuit video. Given the lawsuit video is all about plaintiff's decision to file the present action, Ethan Klein's statement that nothing happened could easily refer to the fact that no action was filed in the intervening months, not that the parties had no communication. Second, mention of the warning email would not have produced a different effect on the mind of the reader than what defendants actually said. If plaintiff has alleged, the ordinary viewer would see plaintiff as a trigger-happy litigant after watching the lawsuit video, it is exceptionally unlikely that knowledge of the April 2nd email, in which plaintiff explicitly threatened costly legal action if defendants did not comply, would change that perception. In other words, the pleaded truth would do absolutely nothing to undercut the allegedly defamatory implication of the statement, though the court disagrees that Mr. Klein's statement carried that implication. Because the statements identified by plaintiff are either non-actionable opinions or substantially true as a matter of law, Claim 3 is dismissed. Conclusion. For the foregoing reasons, defendant's motion for summary judgment is granted in its entirety, and plaintiff's motion for partial summary judgment is denied. The clerk of court is directed to terminate the present action, so ordered this day, August 23rd, 2017, Catherine Forrest, United States District Judge. What do you think of that? That was everything we thought it was going to be, right? Like we knew Matt Haas was going to be just flattened, right? I mean, absolutely riggedy wrecked. I mean, the video was clearly a fair use. It's clearly critical commentary. There is no reason for this lawsuit. So, holy crap, that's the lawsuit. Now, we've been at this for now 44 minutes to get through that. I'm sure some of you have joined us a little bit late, so let's take some questions and maybe go over a summary again. What do we think? You missed the start of the video. Yeah, let's go over the start of the video real quick again. I'll bring it back up here and we'll just read through the introduction one more time. this is the beginning here, the introduction, and it's only going to be like this 3 paragraphs here. So stick with me for 30 seconds. This action principally concerns whether critical commentary on a creative video posted on YouTube constitutes copyright infringement. Matt Haas filed this action in response to the Klein video, in which they comment on and criticize plaintiff's copyrighted video. The Klein's criticism and commentary is interwoven with clips from the Haas video. The operative complaint alleges that defendants infringed plaintiff's copyrights, made misrepresentations in counter takedown notices, and defamed plaintiff. Before the court are dueling motions for summary judgment. The key evidence in record is the videos themselves. Any review of the video leaves no doubt. It constitutes critical commentary of the Haas video. There is no doubt that the Klein video is decidedly not a market substitute for the Haas video. For these and other reasons below, defendants' use of the clips from the Haas video constitutes fair use as a matter of law. Further, it is clear that the defendants' comments regarding the lawsuit are either non-actionable opinions or are substantially true as a matter of law. For these and the other reasons set forth below, plaintiff's defamation claim fails. Defendant's motion for summary judgment is therefore granted in its entirety, and plaintiff's partial motion for summary judgment is denied. So there it is. That is, why are you not selecting? This is, okay, I'm not even going to try it. That's it. That's not the end of the case. So what happens now? Well, Ethan and Hila and their attorneys get to celebrate. They get to relax a little bit and celebrate. We already knew a little bit that this was going to happen, but we were eagerly awaiting it. I was kind of hoping that it would have been a much shorter wait, and the Kleins and their attorneys would not have to wait 5+ months for this opinion. But they got it. They got it. They won. The case is just about over. From here, what can happen? Well, Matt Haas can appeal. I highly doubt it. Highly, highly, highly doubt it. I don't know that an attorney would even take his case to appeal it, let alone that he could afford to pay an attorney to appeal. So I give it a next to 0% chance that Matt Haas would appeal. But he could. He could appeal. The Kleins, on their side, h3h3, could make a motion for fees and costs. Could ask the judge, since the case is so clearly in their favor, to grant them a judgment for all of their attorney's fees and costs against Matt Haas. That means that Matt Haas will very technically owe them many thousands of dollars, probably into the 6 figures for how complicated this case got. Can Matt Haas pay any of that? Highly doubt it, but that's going to be up to Ethan and Hila and how they want to handle it. You may remember that Jim Sterling handled one of these by getting a written statement from the opposing side. I think it was James Romine, saying an agreement basically that he was not going to do anything anymore, and therefore Jim Sterling was not going to pursue him for cost and fees. What Ethan and Hila could do is something similar. Make some kind of agreement that as long as he leaves them alone, they won't pursue him for fees and costs. That said, I'm a little less forgiving sometimes. As much as I'm a nice guy and I want you to love me and all that, I would probably get the judgment against him and then just hold on to the judgment and see if he's going to come up with some kind of deal or payment, some portion or something, in order for us to remove the judgment from his record. I wholeheartedly feel that he should suffer the natural consequences of his actions. This is a terrible consequence for anyone to face. On Ethan and Hila's side, they should not face unnatural, arbitrary consequences for having created a video that is critique and commentary. We all should be able to create critique and commentary. How else do we call out the bullshit in this world? So It's very important. So the defense of that right is very important. And honestly, the natural consequences of Matt Haas trying to take advantage of the law should be that he has to pay for the defense of his actions. And that's $100,000 or more. Oh well, guess he's got to make a whole bunch of great YouTube videos now so that he can give that money to Ethan and Eli, if they decide to go that route. I mean, they could take the high road, they could take the middle road. We're probably not going to take any low road. We know them, right? But you know, the high road, for totally forgiving the thing. You may sit on it for a few days. I think they have I think your motion for fees and costs is due in 2 weeks. I think. I'm not sure. That's not legal advice. It's just my best recollection. So, okay, I love this picture that was just posted. I don't even know how I can get this on my stream, but someone just posted a great picture of Ethan making one of his quintessential Ethan faces, but it is with the quotes quintessential Judge Catherine B. Forrest 2017 under it. That is absolutely great. Brandon, you should probably try and make that into the thumbnail image for this video. That's awesome. Yes, you can rewind the stream. Papa bless. Thank you all for your donations. I've seen a number of them scrolling through here, and I probably missed a bunch of them, so I think I can actually go back here and see if I can find them all and call you out. Super chat. If they started a crowdfunding campaign for the costs, I don't know what that means. Oh, Scandinavian Tipping War. Thank you, Jesper, for the 20 Danish kroner? Swedish kroner? Are there other... Oh, geez, I see SEK and DKK, and I once again have forgotten which is which. Wow, thank you, Jesper. Thank you, Poopoy. Thank you, Erik Danielson. Thank you, Magnus Johansson. Thank you, HODO4. Thank you, Tom Resnick. Thank you, The Good Content. Thank you, Jonathan Newman. Thank you, Zuber Ruber. I will get to what inter alia means as soon as I remember what inter alia means. Bad lawyer. Among other things. That's why I don't remember it, because it's not terribly important. It just means among other things. Inter alia means among other things. Thank you, Nick Ramos. Thank you, The Derbinator. Thank you, Termy93. Riggedy Wrecked. Thank you, Maybeck. Thank you, Hebe the Ink Fox. Thank you, Lon.tv. Thank you, Vienticus. Thank you, Nancy D. Thank you, Erik Danielson. Thank you, Morse Apple. Thank you, Michael. Thank you, Super Dur. Thank you, Jonathan Newman. Thank you, Zuberuber. Thank you, Joshua Walker. Thank you, James Studer. Oh, now I'm back into the last live stream. Sorry about that. Thank you, Trigvi Rasmussen. I don't know if I've even got close to right. Thank you all so much. So Sweden, Denmark, Norway. Got it. Denmark, Norway, Sweden, Denmark. Wow. You guys can have a tipping war all you want, but please don't go broke. I love you all, but I'm doing okay over here. You know, only give if you really, really want to. So thank you very much for all of that. I have got to find a way to get this picture on this stream, because this is just the best. Copy image. How can I paste this into something? No, you know what we can do? Let me put it in another browser that actually works. Firefox. No, I think I have Edge working. Play an ad, fam. You're cool. I don't even know how to play an ad on live stream. I'm not even going to do that. Okay, so window capture, Firefox, add existing, Firefox. Okay, but that obviously didn't work. Okay, never mind on that. We'll try it in Firefox, I guess. Thought Edge was working fine. Yeah, so we can talk about the FUPA. This is I don't know that now is the best time to talk about the FUPA. I don't, and this is not on inside knowledge or anything, so I don't want anybody to do the Matt Haas thing and think that I know something about there. That's the image that was sent to me. That's amazing. That's absolutely amazing. So anyway, the FUPA is not, I don't mean that the FUPA itself is controversial. I mean the concept of a shared defense fund is sometimes difficult to do. Some cases will come to you that are not meritorious. I get lots and lots of inquiries where people's cases are in between good and bad, where you might never go to court on it because the case is just does not make a good presentation in court, and the defenses, maybe they don't have the greatest defense, but they have enough of a defense that it would be difficult. So do you spend FUPA money? Do you spend donation money on cases that aren't the best? If the case was obviously going to lose, okay, great, yeah, we don't take those cases. We tell people why those cases are going to lose, and we try not to take all their money, at least if we're a moral and ethical attorney or person. A case that's clearly going to win, great, spend all the FUPA money on winning the case and then get the FUPA money back and put it back into the FUPA. Great. What about the cases in the middle? There are so many of them. Cases that are less clear than h3h3. There are so many of them that you're going to spend the FUPA money triaging or sorting through all the cases. So even in a good world where you raise $100,000 of FUPA money, which I'm all for, that then someone has to determine, someone has to be kind of the trustee, someone has to determine who uses that money and how much. And what if you spent most of the FUPA money and then a better case comes along? How do you determine whether you take money from the previous case to give it to the next case? It's a very difficult question. So I'm not bashing the FUPA. I'm concerned about just dumping money into a common defense fund without further guidance and without further understanding of what we're using it for. So it's not that it's a bad idea, that the idea is great. I love it that you're thinking about how to help others and how to help our community grow and protect itself. That's amazing. That's awesome. I'm concerned about what's going to happen the first time a terrible case gets to use that money, or a person successfully lies their way into using that money. What are you going to do, get it back from them somehow? It's going to be just more controversy, so it's better to not make those mistakes up front. Anyway, not bashing the FUPA. We don't, I'm sure the FUPA can take a pounding, but we are not bashing the FUPA. Do I read chats? I do read chats. Usually my chats that I'm reading are on a Discord. My Discord server is somewhere. Maybe my assistant, Captain Yosho, can update the description of this stream with the Discord link. I was asked at some point to say something, but I was going to work it in at some point. So maybe I'll do that if you've seen Captain Yosho's message. I'm going to work that in at some point here in this stream. Thank you very much, Jonathan Eilath, for the Scandinavian tipping war, the Danish kroner 50. Thank you. Appreciate it. Can they re-upload their video now? Oh, absolutely. They probably didn't ever need to take it down, and that was probably more of a cautionary recommendation from their attorneys. If I was their attorney, I probably would have also recommended taking it down. Otherwise, Matt Haas would have had a claim for an accumulation of damages over time if he had somehow won. So not that we expected him to win, but we don't take these chances if we don't have to. The video was not worth millions of dollars or wasn't someone's special video. So we just take it down, and heck, the controversy was enough of a Streisand effect for it, wasn't it? So, do I stream on Twitch? I do stream on Twitch. It's under Leonard French. It's mostly PUBG. Yes, Twisted Grizzly, H3H3 There is an update to the H3H3 case. The judge shut Matt Hoss down on pretty much all counts. She did acknowledge that his Bold Guy is a work of fiction. She did acknowledge that the Kleins used most of his video and that fair use factor did not go in anyone's favor. But ultimately, she said that the fair use went in favor overall of H3H3 because they were offering critique and commentary and not usurping the original market for the work. Wow, I am so distracted by your amazing tips. Masturbation Messiah gives 20 Norwegian kroner. HODO4 gives 50. Leonard, I need an attorney. I want to sue the Swedes for not tipping enough. Mark Nelson gives 20. Can Wisconsin join the tipping war? Aramal gives another Norwegian 100 because we have more money than other Scandinavian countries. Wow, I love you all. Thank you so much. The Brilliant Earth defamation suit. Yes, I'm going to be covering that later this week, I hope. I do owe one of my sponsors a fully produced video. I think I'm going to prioritize that because I do not want to get to the end of August and have not prioritized his video. So thank you very much to New Sensei for sponsoring a Basics of Copyright for YouTubers. Guess what opinion can now be in my next Basics of Copyright for YouTube video sponsored by New Sensei? It can be the H3H3 case, because look at how much great case law is in here for defining fair use and what constitutes fair use. We can show, maybe I'll get permission from the clients to show parts of their video as an example of how you do fair use on YouTube. So this is a positive thing for everyone except Matt Hoss. So thank you all very much. Thank you, Stuart Brown, for your 100 Norwegian kroner. Let's see. No, not even going to repeat what you just said. Another 20 tip from Masturbation Messiah. Tip to make Leonard sue the Swedes. I don't know. I think Sweden, Finland, Norway, the Netherlands are some of my favorite countries. They're some of the coolest people in the world are from those areas. I don't want to piss them off. You know, I follow Rallycross as best as I can from the States here because, you know, how can you follow it? They don't publish much. But, wow. Yep, so once again, H3H3 won the case that Matt Hoss filed against them. Matt Hoss's lawyer will break it to him by saying that they lost a summary judgment motion and then explaining it. He will probably, I don't know what his arrangement is with his attorney, so I think that Matt Hoss's attorney is not going to get much more money out of anyone for this case. He probably has a big bill for Matt Hoss too if he's done his homework. And I'm pretty sure that H3H3 has the right, not necessarily, I don't know what they're going to do, I'm not speaking for them, but they have the right to request fees and costs, all of their fees and costs, and you saw how big some of those bills were, from Matt Hoss. So that doesn't mean that he is going to be able to pay it anytime soon, if at all ever in his entire life, but they could maintain the judgment, and he could have to pay it off slowly over time. They could use his state's law to garnish wages, or acquire property, or get liens on property, or cars, or things like that. So that really could be a bad time for Matt Hoss if the Kleins decide to do that. So I guess we'll see whether they decide to use the goodwill of letting him go, or whether they try to maintain the judgment, or what. I mean, maybe they and their attorneys will find a middle ground. I don't know. Thank you, Mormon Jesus, for the Norwegian 50. Sue and make them pay for it. Put up a wall. Make them pay for their wall. Yeah. A copyright wall. It'll just be an anti-copyright infringement wall. Nothing else. Spongeworthy Esquire, $5. Was the judge's clarification of the good faith subjective standard for counterclaims new? No. The Ninth Circuit has adopted the subjective good faith standard for violations of DMCA 512. I believe it's 512F and G are the ones we're talking about. And those violations if you make a violation, but you genuinely, sincerely believe that you were correct, that you were not incorrect, that you were not mistaken, then you can't be held liable ultimately for your mistake. But you're going to have to offer evidence that it was a genuine mistake and not just a testimony that like, oh, well, I thought I was right. It's going to have to be genuine. So what the Kleins offered was an actual written policy, I believe it was, that they show how they go about cutting things up and editing things so that they make sure not to fall foul of fair use. And I believe the judge agreed with that as a mitigating factor that they genuinely considered fair use. 9 and 7 says, I can't wait to see the h3h3 video about this. Me neither. That's going to be fun to see what their reaction is. I hope they seem relieved. They probably knew for a while now that it was going to be in their favor, but, you know, how can you ever be sure? So, I'm Leonard fucking French, son, and thank you for joining me. And if you have questions, you can go ahead and submit them now. Could Matt Haas sue his attorneys for malpractice? Well, he could sue them. I don't know that he'd be successful. I don't know that his attorneys did anything wrong. The malpractice would have to be if his attorneys somehow did something incorrectly. He made the arguments correctly. He did not win the case. That's not malpractice. Losing a case is not malpractice. He would have had to have committed some kind of other ethical or moral violation. Calum Bailey, would the fact that some of the legal fund was crowd-funded affect reclaiming those costs? No. The judge, so Matt Haas might oppose the reclaiming of those costs and might make all of his possible arguments, and that is one possible argument. I do not think the judge will find that because some of the legal fund was donated, that means that they don't have to get those costs. Those funds were not donated to Matt Haas. They were donated to Ethan and Ela Klein. So Ethan and Ela Klein should get to keep that money if they can get it back from Matt Haas and do with it as they please. If they decide to donate it, great. If they decide to keep it, great. If they decide to open up, put it into a fupa, great. They can stuff it right up in that fupa and leave it there for as long as need be, and they can take it out whenever they need it. Just, you know, take the whole wad right out of the fupa whenever they need it. It's their fupa. Unless they set up the fupa as like a separate trust or something, and then there's like a second person that's always there making sure the fupa is healthy and managing the fupa and giving people access to the fupa when appropriate. So, I'll stop with the fupa. Okay, so yeah, that's their money basically. For anyone not understanding why I'm making all the FUPA references, the FUPA was the fund, the Fair Use Protection Fund that the Kleins had started. And so it is a play on another acronym, but what we're referring to is the Fair Use Protection Account. That's all I'm saying. I am not saying anything derogatory whatsoever. Okay. So how is everyone? We feeling pretty good after that? Yes, I think there are some dogs. Hey, are there any dogs? You know what? I might have to. They might be outside. Let me go find my dogs outside. Can you give me 30 seconds to run downstairs? Stick with me for 30 seconds, and dogs will be right back with me. Be right back. Come here. I called both of you. Where were you? They were inside the whole time. Come on, hup. Come on, Elsa, hup. Okay. Go. Well, that's not chewing a treat. Come on, eat the treat. Come here. I gotta carry you because the camera's all the way up there. Oh. So say hi to Elsa. This is Elsa. And Ilsa can have another treat. Because she's a good girl. Because she's a good girl. This is my Ilsa. Did you just drop that? No, okay. Okay, I know. You want to get down. You don't like to be held. She's my shepherd. No, you can't have more of those. You didn't stay up. You have to stay up. Nico, let me get you. Oh, you're so heavy. So big, dog. So big. So big. Matt Haas, more like Matt Loss, am I right? Arron, thank you very much for the $5. So this is Nico. Nico has a little spot on his head because he got a bug bite and had an allergic reaction to it. But he's healing. And this is my therapy boy. Not really a therapy boy, but you know what I mean. He's he's doing his little love grunts too. Yup, he's my big boy. Cuddles with me at night. Oh. You want another one? Being a good boy. Being a good boy. Yeah. Yeah. Huh? Say hi to everybody. Say hello. Make a video of yourself ending a closing statement in court with, "Because I'm Leonard fucking French, Your Honor." I could probably arrange that if I had the judge's permission ahead of time. They don't usually let us take videos in court first, and they definitely don't like it when you make light of the court process. What just happened? My stream just froze. What is going on? Okay, now it's back. I don't know what that was. Sorry about that. Okay, are we back yet? Back, okay, great. Excellent. Well, thank you all for joining me. Let me see some of your questions. That was some kind of lag spike, or one of my old hard drives had to spin up or something. Why does H3h3 not have to file a counterclaim for damages? Is it section 505 of the copyright code? Austin Anderson, yes, you are correct. 17 USC 505 is a fee-shifting provision that says that the winner, the prevailing party may, or rather the prevailing party, upon application, the judge has the discretion to give the winning party their attorney's fees and costs from the losing party. So that's how that's able to happen. They don't even have to file another court action. Hi. Hi. I don't know if I can adjust this in live, but we'll try it so that people can see you. No, that's the plate. That's not the... Oh. Where is Doggo? There is Doggo. Oh. Nico. Just move the camera so everybody could see you. Come here, boy. Come here, boy. What a good boy. So, Ela Klein tweeted about them winning. Great. Did we drop the mic? No? Okay. For those who just tuned in, Ethan and Ela Klein won their case. The judge said that their video was a fair use. The judge said that they were not guilty of a DMCA misrepresentation or guilty of a defamation violation. So they won. They can now request their fees and costs from the opposing side if the opposing side can even afford that, I don't know. All right, I'm going to move the camera back up here. Raw. Not perfect, but it'll have to do. Raw. Good enough. How did I decide the names for my dogs? Well, Ilse is the German Shepherd, and Ilse is a very strong German version of Lisa, so that's why I like that. I happen to like the name Lisa, and Ilse was just another version of it. It sounded good to me. Nico is short for Nikola Tesla. I'm a big fan of Nikola Tesla, the inventor, scientist, engineer from the early 1900s. So, okay. So that's our stream. I don't think there's too much of a point in just hanging out here trying to rehash everything over and over and over again. If you would like to see the content, just watch the earlier part of the stream. This will be posted as an archive, and it takes a moment for YouTube to process the archive, so I expect that to be up shortly. Can I get a rip in the chat? I don't know what you mean by that. So there you go. So thank you very much to everyone for joining me today. I am Leonard French, your favorite copyright attorney. I have a couple sponsors that I'd like to say thank you to. First, New Sensei is supporting at the $500 level for a video Basics of Copyright for YouTube Creators, which will be coming out shortly and will now contain this case. We'll be going over what you need to know about fair use and copyright for YouTube. And I'm going to be able to include Judge Forrest's opinion now. My $50 plus supporters are Joshua Meinzinger, Baxorn, John Cripps, Nate Beck, John Steele, Westin, Lohne, and Lydia Collinson for the month of August. Thank you very, very much. And my $5 plus supporters will be in the description below and are scrolling on the LED panel that was behind me until I adjusted the camera. So thank you all very much for coming. I have a Discord server, which Brandon can post a link to if anyone would like to join our live discussion and live chats that we have there. I stream on Twitch under Leonard French, do video games and stuff like that, PUBG mostly. There's a few others from time to time. Ace Attorney's in there somewhere at some point, etc. Let's see what else. I don't know what else we really need to announce. There's some other things coming up, but I don't have anything set in stone yet, so I'm not going to waste your time. Thank you very, very, very much for joining me. I'm Leonard French, your favorite copyright attorney, and I will see you in my next video. Thank you very much to all of the h3h3 fans who have been joining me for this analysis, for the duration of this case, who have come and subscribed to my channel. I appreciate you all too. So thank you all, and I'll see you later.